Hello, everyone. This is Dr. Selassie, and today what we're going to be talking about is the Constitution of the United States and origin of the Bill of Rights. So let me cue up our presentation here so we can get started. The American Revolution took place between 1765 to 1783. And after the American Revolution, the country moved to what we call a war drawdown. In other words, there was no fighting, so soldiers could go back to their own homes. There was no need to manufacture or to harness the ability to get weapons. But there are a couple of things that stood in the way of the United States from making a country, and that the country itself was in a low-grade chaos. And what we mean by that is that you had pretty basically a series of states, 13 colonies who were going to become states, that now were not tied to any governing country. These colonies were separate and had their own ways of doing things and their own sort of cultures. And so there was no particular way for these colonies to act effectively as a country. So what they recognized that they needed rather quickly was to have some type of governing document. So what you have is a situation where you have 13 individual governments, and now the recognition that you needed to have some defining or set of principles or a document that could allow these 13 colonies to function together as a nation. So they decided on putting together a document called the Articles of Confederation that would cement them in what they called a firm league of friendship. Now, if you can just get a hold of your mind to the words here, a firm league as opposed to a non-firm, a loose, and friendship. So what we have here are 13 colonies who each believe that they are separate and sovereign, that they are standing together because they share the commonality of one, having English heritage and a Protestant religion, and they all work together to fight against the British government. So they had those things going for them, but they saw themselves as separate colonies with separate individual governments. So here are the 13 colonies, starting all the way up from New Hampshire, Massachusetts, Rhode Island, Connecticut, New York, Pennsylvania, New Jersey, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia. These are the 13 original colonies. Now, the Articles of Confederation were created in 1777 and ratified in 1781, and almost immediately there were problems with that document. There was, for one, no way to collect taxes for government expenses. So if you might have a national government, there was no way that the national government could have a revenue. What they had to do was depend on each of the colonies to provide money for the national government. And as you can see, that the deficiency is inherently built into that. What happens if a state or a colony decides that it does not want to give money? There was no way for the national government, through the Articles of Confederation, to sign peace treaties for all 13 of the colonies. So in other words, if France wanted to have a treaty with the United States, it had to sign 13 separate treaties. There was no way to provide for common defense. There were still a lot of animosities between Great Britain and the colonies, and they fundamentally knew that England was their enemy. So how would they, in fact, then raise an army? Well, the Articles of Confederation did not call for this. Now, the Continental Congress that met to raise funds and to do all of those things like raise a national army was completely disbanded. So what you had here is serious deficiencies in a document that was supposed to allow the colonies now moving into statehood to function as a national whole, but this was impossible through the Articles of Confederation. So there was a proposal put on the table to convene a constitutional convention so that they could in fact discuss moving away from the Articles of Confederation and adopting some firmer document that would allow or sort of move away the deficiencies inherent in the Articles of Confederation. But almost immediately, a strong opposition grew because people who were, or the founding fathers, who were sent to discuss this, realized that there could be a tendency for some major issues to rise when this new document, a constitution, was written. This group of people that began to have serious doubts about a constitution, we today call the Anti-Federalists. Later, the discussion would move towards, at the insistence of Patrick Henry, a Bill of Rights be added to the Constitution to protect individuals from an overbearing state government, as they believed England, Great Britain, had been overbearing towards the colonies. There were some influential texts that guided the framers. Most of them were well-educated. A few, like Benjamin Franklin, were not, but many of them were well-educated. Most were wealthy. A large number of them were slave owners. So they had the type of education and influence to be able to refer to text to guide them. One of them was Politics by Aristotle, that laid out alternate forms of government. One of the major questions that these framers had, the founding fathers, was what type of government should they have? And there were a lot of different types of governments: theocracies, monarchies, constitutional monarchies, right? So the discussion would have been, if we're going to put together a new government, what type should we have? Machiavelli, whose Discourses on Livy, argued for the ideal form of a government would be a republic based upon popular consent and defended by a militia. There was John Locke's Second Treatise on Civil Government that proposed the idea of a social contract. Now, a social contract is essentially an implicit agreement of members of a society for benefits. So in other words, you agree as a citizen to do certain things like pay your taxes, and the government therefore then has an obligation to do things like protect your private property. This is a contract. You do something, they do something, and as long as the contract is being fulfilled by both sides, then you can have the semblance of a government and all is fine. So these fundamental ideas, thinking about alternate forms of government, what types, maybe the best type of government according to Machiavelli would be a republic, and then a republic based on some type of an agreement, a contract, binding both the government and the people together. The Constitution was created in 1787. ratified in 1788 and came into force in 1789 with 27 amendments. The preamble to the Constitution reads, "We, the people," and we have here an emphasis put on the people because unlike when the colonials were under British control, they were subjects of the king or queen. But here you have a radical new concept where the people are in charge of their own affairs. Today, we kind of take this for granted and we say, what's the big deal about that? But during its time period in the 18th century, this was a radical idea that ordinary people, even uneducated poor people, had a say in government. Now, it wasn't always that in the United States that even the poor had a say, because there were sometimes from state to state property requirements and that sort of thing. And as we progressed on with the disenfranchisement of blacks and other minorities, we had literacy tests and all kinds of things. But the fundamental idea here is that non-nobility, people who were not part of the aristocracy or nobility, were going to take charge of a government. That in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, meaning the future, do ordain and establish this Constitution of the United States of America. Now, this preamble is absolutely important. The entire civil rights movement and its subsequent movement for LGBTQ rights, women's rights, etc., even we can think of things as disability rights, fall under this because establishing justice, ensuring domestic tranquility, promoting the general welfare has not always been at the heart of our American nation. Slavery existed under this Constitution. The disenfranchisement of women existed under this Constitution. Segregation of blacks and other minorities existed under this Constitution. So for the better part of our American history, the United States has not lived up to its own Constitution. And I think here, in order to form a more perfect union is appropriate because the founders did recognize that they weren't establishing a perfect nation, that there in fact were issues. They were trying to create a more perfect union. And I think this statement, in order to form a more perfect union, makes the Constitution one of the best documents or contracts, if you will, for a lack of a better phrase, that has ever existed, because it is always moving towards more liberty and more justice. Article 1, Section 1, the legislative powers herein granted shall be vested in a Congress of the United States and shall consist of a Senate and a House of Representatives. Now, we know that this idea here, this bicameral idea where you have two legislative houses, a Senate, members elected every 6 years, a House every 2 years. The Senate looks out for the state, the House for members within its own congressional districts. They have two fundamentally different purposes, but they act in concert together to pass laws, to write laws. The executive power shall be vested in a president of the United States. He shall hold his office during the term of 4 years, and together with the vice president, chosen for the same term, elected as follows. And there is standard language for that. Article 3, Section 1, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts, those are the lower courts, as the Congress may from time to time ordain and establish. So here we have outlined the separation of powers, a legislative branch, a executive branch, and a judicial branch. Now, in our key issues that we looked at the beginning of the class, we already have some fundamental idea how these different branches of government work. They are co-equal branches of government. Now let's take a look at the Bill of Rights, which I think are at the heart of the U.S. Constitution. Now, some people think that the Constitution is actually two documents, a Bill of Rights and a Constitution. The Constitution itself basically outlines how the government should work. Some people think that the Bill of Rights are part of the U.S. Constitution. For me, tomato, tomato, either way you want to look at it is fine. I've heard good arguments on both sides. So it's fine with me for you to say or to think of it one or the other. The Bill of Rights, I believe, are divided into these 6 fundamental big ideas that are vastly important. Limited government. One of the things that the framers talked about was the idea to limit the size of the federal government and its reach because there were already 13 state governments. The idea being here that primacy would be with the state governments because everything was local, or you can just boil it down to, as Tip O'Neill once said, all politics is local. You're more likely to know your congressperson than you are to know your senator, because they're in your congressional district and you can just go down to their district office and say you want to meet. And if they're there, they will meet you. You can think of it in the sense that England was 3,000 miles away and was dictating the affairs of the colonies. So the framers thought, well, why should we have a national government hundreds and hundreds of miles away when our own state capital is right down the road and we have better access to our state governments than we do to some national government who's going to rule by fiat, just like England had done. So limiting the size and scope of government was primary. Republicanism. The idea here being that you would have a government that was representative of the people. In other words, the power that the government has is going to derive directly from the people. And that you, while you may not have the ability to go down to the well of Congress and express your views, you have people that you specifically elect on your behalf to go represent you in Congress. And there is this reciprocal relationship between you and that person who goes into Congress or government. Checks and balances. Separation of powers. The legislature can check the president by overriding the president's vetoes. The president can check the legislature by vetoing any law passed by Congress. If Congress and the president move on a bill and it's not constitutional, the U.S. Supreme Court can check the president and the legislature. And if it's so important, and you know that the Supreme Court is going to check it, you can just have a constitutional amendment. Federalism. The division or power between the nation and the state. So what federalism means is that you are putting together a government that will outline in detail the division or separation of powers from the nation or the state. So the nation will have powers. The nation and the state will share in some powers, like the ability to collect taxes, and the power of the state government on its own. So, for example, if there is a murder, let's say, in California, the state has the right to investigate the crime. Most crimes are investigated by local and state governments. So that is a direct separation of power. Inherent separation of powers, as I've outlined before, and then popular sovereignty, which means letting the people decide. The people have the power to influence government. So why a Bill of Rights? The Bill of Rights consists of the first 10 amendments to the U.S. Constitution, amendments so important that they thought that they needed to be included right away. What the thinking here is that the government may at any point have so much power that it could usurp the power of people. So the Bill of Rights are your rights that you have against federal intrusion. Some people will say things like, I know my rights, I know my Constitution, I have rights. Wrong. Yeah, you may know them, but you think that your rights are vis-a-vis other people. No, these Bill of Rights in the Constitution are your rights vis-a-vis government, the federal government. The government cannot trample over certain rights that you have. They are grounded in English law. And what we mean by this is that the Americans were English subjects, so they took their cues from English law. That made sense to them, but they were shaped by an American experience. The Bill of Rights incorporates the social contract theory, as I discussed earlier. They are so important, these Bill of Rights, that Ralph Waldo Emerson once said, "We began our government with freedom." The Bill of Rights in the U.S. Constitution wasn't a new thing. The first Charter of Virginia in 1606 contained provisions for a Bill of Rights. For example, colonists shall have and enjoy liberties, franchises, and immunities as if they had been abiding and born within our realm of England. So here what they're saying is that just because you're in Virginia doesn't mean you don't have the rights enjoyed by all English people. The American experience itself eased the way to written constitutions. The land charter in Virginia gave people the right to hold land, to inherit, and trials by jury. Americans were just accustomed to having more freedom and demanded such. In the colonies, they had not gone through a feudal stage. There was no rigid class systems as they exist in England. Now, there's our class systems, and don't ever think that in the United States there's no such thing as class. There are. Look at all the presidents. They're all well-born, all have Ivy League type educations. If they don't have an Ivy League type education, they're all wealthy. You will not have, I think, ever in the United States, an absolutely destitute poor person ever becoming president without an education. It won't happen. But we had a less rigid class system, because today what's unique about America is that you can make a lot of money and get certain entrance into certain class systems. But in other places in the world, you can't do that. It's very difficult for non-wealthy people to get into Oxford and Cambridge. A lot easier for non-wealthy people to get into Harvard. Difficult, but a lot easier. They had no arbitrary despotism of kings, no established church. So it paved the way for things as the United States were getting underway. Virginia Constitution in 1776 started out with a Declaration of Rights. All men are equally free and have an inherent right to even be divested, even by compact. The Northwest Ordinance declared for a Bill of Rights. Now, the arguments for a Bill of Rights came into real crystallization and debate over a series of articles called the Federalist Papers that were written by Alexander Hamilton, John Jay, and James Madison. They were published anonymously under the name Publius. And these articles that appeared in the newspaper were trying to get and to promote ratification of the Constitution. So James Madison in Federalist 84 called for limits of powers of government, preventing legislative and executive abuse, and preventing tyranny of the majority. So let's take a look. First Amendment, Congress shall make no laws respecting an establishment of religion or prohibiting the free speech thereof. So we don't have a national religion. There shall be no prohibition on the free exercise of religion. So you can think of any religion you want, and you're free to exercise your religion. Or abridging the freedom of speech. Now, this one has been curtailed in a lot of ways because we really don't have a thing called free speech. We have a thing called protected speech. You can't say anything that you want. So in other words, if you walk into your office and you start screaming racial epithets and you get fired, you can't say that you have the right to free speech. No one's going to put up with that. You can't walk into a movie theater and yell fire and everybody jump out and run and somebody gets killed and you say, I was just kidding, I have my free speech, I can say that. You're going to jail. There is a thing called protected speech, and Congress has outlined what are forms of protected speech. No, Congress shall not make any laws prohibiting the free exercise of the press, the right of the people to peaceably assemble. And you're seeing this with the George Floyd murder, where people are protesting and you have anti-protesters who don't want Black Lives Matter or other groups to protest, specifically the police. People have the right to peaceably assemble. And you have the right to petition your government for redress of grievances. So you can call your local council person, your local senator, your local congressperson, and you can tell them, I want to meet with you to talk about my grievances. This amendment, the second, is probably the most controversial, the right to bear arms. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Many people say that, oh, this doesn't give you the right because it's only under a well-regulated militia, and I'm afraid that just isn't the case. The founding fathers would not have understood any talk about removing weapons from citizens. They lived under a very different time where people just didn't go out in the streets and shoot each other in drive-bys. That was just something that was absolutely unheard of. So for them, they wanted everyone to have a rifle and the ability to assemble in a militia if necessary. This had always been part of English common law, that when militias were called, that you would bring your own musket. Even the states have a right to allow people to develop militias, as long as the states have a law for that. And in some states in the United States, particularly in the South, there are laws that allow people to do that. Quartering of soldiers. No soldiers shall in time or peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So in peacetime, they have to ask you, and if you say no, then they can't stay in your house. In a time of war, there has to be a law that outlines how that's going to work. Search and seizure. The right of the people to be secure in their persons, houses, and papers and effects against unreasonable search and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This is intended to protect you from government, like the police, state power, from just coming into your home or to your car or what have you, or your office, and just seizing things that you have. They have to have probable cause. It has to be reasonable. They have to have a warrant. And that a warrant has to be affirmed by a judge. And it has to outline who, what, when, where. Now, this has been severely eroded over time by the Constitution that has skewed more Republican and conservative over the years. So in other words, what is probable cause? So if a policeman is walking by your house and he hears somebody screaming, does that mean that they have probable cause to break down your door and to find out what's going on? Probably yes. If the police stop you and they say, you look mighty suspicious, what are you doing? Can I search you? Or they just start searching you. Do they have a right to do that? If they say that you look suspicious and that there was probable cause to search you, and they demonstrate that there was probable cause, they're probably in good stead. What you should do every time the police want to search you is tell them you're not giving them consent to search you. Just say it. I don't give you consent to search. Whip out your phone, turn it on, and say, I do not give you consent to search. And then that forces them to demonstrate that they have a right to do that. Sometimes the police will argue that if you didn't have anything to hide, you would have allowed us to search you. But do not ever give police the right to search. Force them to give a warrant. Now, sometimes there might be just some ridiculous things, like if you're driving your car and everybody's stopped and there's a manhunt because somebody escaped from prison, and the police have stopped all traffic and they say, look, we're just looking for the guy. Do you mind if we search your trunk? Just pop your trunk open. Just cooperate. But if you're just driving down the road and a cop car comes up behind you and pulls you over and says you look suspicious because you're driving while black, brown, or what have you, don't give them consent. Cooperate with the police, but don't give them any consent. the right against self-incrimination. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Nor shall any person be subject to for the same office twice, double jeopardy. So in other words, here, you can't be tried for the same, like if you commit murder, a capital crime, you can't be tried over and over and over again. Nor shall a person be compelled in any criminal case to be a witness against himself, nor deprived of life, liberty, or property without due process of law, nor property shall be taken for public use without just compensation. So, in other words, here is that when the police stop you, just don't say anything. Give them the basic information. They stop you. Who are you? John Smith. Do you have ID? No, I don't. You don't need to carry ID with you. Now, you should always consult with a lawyer because I am not a lawyer, but what I'm telling you here is you do not have to answer for anything. If you get stopped and they want to take you to jail, don't say a thing. Don't say anything. Just give them your name, and that's basically about it. And just keep saying over and over again, I want a lawyer. And they keep telling you things, you just keep saying, I want a lawyer. Don't give anything here that can incriminate you. Right to a speedy trial. They can't hold you in jail forever. Although they have done this, they cannot do this legally. Right to trial by jury. Freedom from excessive bail. This is a really problem for poor people because if you get fined $500 and you don't have $500, then what are you going to do? The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. If it's not listed, it's automatically thought that you have that as a people. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Now, the Constitution, as we stated earlier in the lecture, was not perfect by any stretch of the imagination. Sojourner Truth once said, "From a distance, the wheat field looks fine, but up close one might see the ravishes and blight. The Constitution feels the same way. I look for my rights, and there aren't any there. The Constitution, like a wheat field, had a little weevil in it." So the Constitution, from Sojourner Truth, the great abolitionist, black abolitionist, believed that the Constitution denied her and other black people constitutional rights. William Lloyd Garrison, the white abolitionist, stated that the Constitution was a covenant with hell. It was a slaveholder's document. Why? Because it endorsed the apprehension and return of slaves to their masters, the continuation of the African slave trade until 1808. So the African slave trade ended in 1808, but you could still have slaves. It just stopped people from going to Africa to get slaves. It granted states more representation according to the number of slaves. So if you were a state like Georgia or South Carolina that had small non-slave populations, you were given more representation the more slaves you had. So Jefferson, Madison, and Monroe were all elected as presidents because their states had more slaves and given greater numbers in the Electoral College. So from our early inception as a country, the Constitution supported slaveholding and the slave powers. those slave owners controlled the U.S. government. There was no way for them to get rid of slavery because the slaveholders had power within the Electoral College and greater representation in the U.S. Congress. The 3/5 compromise allowed them to do this, to count slaves, 3 out of every 5. So the Constitution sustained slavery. Article 1, Section 2, representatives and direct taxes shall be apportioned among the several states which may be included within this union, according to their respective numbers, which shall be determined by adding to the whole number of free persons. So you're adding all the free persons, including those bound to service for a term, and that is indentured servants. And we're not even including Indians because they don't pay taxes and they're not citizens. And 3/5 of all other persons, and that is slaves. So most black people had some idea that their rights would be protected under a new constitution, but the founders simply did not mention race. So if you were a free black person, your rights were probably protected under the Constitution. If you were an Indian paying taxes, your rights were probably protected under the Constitution. It depended on the states. Slaves had no protection at all because they were not considered to be citizens. The founders themselves were wholeheartedly ambiguous about people of color, free people. So there was absolutely no definition of who is or how to become a citizen of the United States. That was left up to the states. And as we saw with the 14th Amendment, that allowed for people to have some understanding of how a person could become a citizen. Many states simply just barred black people from migrating into the state, free black people, that is. Some states would allow black people to vote, some states would not. The reason why they were not allowed to vote in some states is because it gave people the right to citizenship if you could vote. If you could demonstrate that you could vote, you were a citizen. So to conclude here, we know that the Articles of Confederation were impotent. A Bill of Rights helped to secure immunities from government abuses. The U.S. Constitution, while it was a great document, was a slaveholding document. And black and minority rights were not secured within that Constitution. Okay, so if you have any questions, please feel free to contact me.